Going. The first of our panelists is Judge Lisa Godby Wood, who is a district judge in the Southern District of Georgia. She was confirmed in 2007 and until just recently was a chief judge, serving from 2010 until this past May. She was formerly also the U.S. Attorney in the Southern District, and she served in that position between 2004 and 2007. She's a summa cum laude graduate of the University of Georgia Law School. She's also on the board of directors, I understand, for the Athletic Association, which is a place you really would want to be if you're a full dog, a double dog, I understand. Yeah. And she's also the first honor graduate for the University of Georgia as an undergrad in 1985. I suppose she was lucky that I wasn't there that year. Our second panelist is Alan Braselton, and Judge Braselton is known to all of us, I'm sure. He's a United States Magistrate Judge serving in the Northern District here in Georgia, and he's been in that position since February of 2001. He was just recently sworn in for his third 8-year term, and prior to that, as many of you would know, he was the criminal defense, white-collar lawyer primarily, practicing within the district, and he's did that for a long period of time before going on to the bench. Judge Braselton clerked for Judge Harold Murphy, who's beloved by all of us, and he's a graduate of the Emory University Law School. I believe he was a graduate along with our good friend Amy While. And finally, getting to our good friend Amy While. Amy is the founding partner of the While firm here in Atlanta, and she practices, as you all know, primarily in the area of white-collar appellate work. And she does just a tremendous job in that area. She's consulted by, frankly, probably most of us here on occasion, just wanting to know what the likely outcome of certain action that we might be contemplating. She served in the U.S. Attorney's Office for 25 years, and 18 of those years she was chief of the appellate division of the office. She's also served as a president of the board of directors for the Federal Defender Program in Atlanta, and she's a recipient while she was at the department of the Director's Award for her appellate work, and has also been recognized by Atlanta Magazine as a super lawyer in the area of appellate law. So those are our panelists, and we've got a number of things that we want to get to in talking about preserving issues on appeal. The core concept, the takeaway is that if it's not in the record, it didn't happen. And so we want to keep those things in mind as we go through and talk about how we preserve our clients' rights on appeal, preserve and protect those rights on appeal, and how do we adequately advocate for our clients in the appellate arena by preserving those things as we go through the process. So we'll begin talking about appellate issues and preservation of issues, starting with Judge Braselton, who deals with these issues initially as a magistrate judge, and then we'll trace those issues and trace the process through its course, going to Judge Wood to talk about district court level issues and the kinds of things that she sees and her observations from there. And then, of course, Amy will talk more generally about primarily the 11th Circuit, but appellate issues precisely. So, Judge Braselton, I'll begin with you and ask for any insights that you might choose to offer on preservations of issues and really talking about clarity of those issues in the motion practice and the issues that might appear before you.
Thank you, Rick. It's always sort of, good morning, everyone. It's always sort of bizarre to tell folks at a workshop how to file motions, because it's usually the folks that think enough to come to the workshop that know how to file the motions. It's like we should just, now everybody's here, now everybody who's not here, let's send an email to and tell them how to do this. But, and a lot of what I'm gonna say, makes perfect sense, but it also makes practical sense, because unlike in the civil arena, where it seems it's much more difficult to find a waiver by a litigant, the federal rules of criminal procedure say that there's waiver when you don't do things at the earliest opportunity. So the first opportunity to present your position in a criminal case is at the magistrate judge level by filing pretrial motions. And, you know, in my district, in the Northern District of Georgia, we don't have, the U.S. Attorney's Office doesn't have what they have in the Southern District, which is so-called an open book for discovery. So the defense is always trying to find what exactly is going on. I've just gotten this huge 3 terabyte discovery disk, and I don't really know what is important and what the government is actually going to prove. And so you try to find this out by the pretrial motions, whether it be a motion to suppress or a motion to dismiss or Rule 17C subpoenas and things of that nature, that you're trying to gather information so you can advise your client. At the same time, you're trying to advise the judge, because the judge knows even less about the case than you do. We're looking at an indictment which basically or usually just tracks the statutory language. In a fraud case, there's going to be a little more detail, but not a whole lot of detail. And so you have to be upfront with the court. You need to tell the judge exactly what it is that you want and why you need it. And of course, in our district, I guess I'm to blame for that. When I came in, we started having a standard order, which is, I know it prevents the filing of pretrial motions which are just done by pushing a button, because we want everybody to sit down and think, what do you actually need? I want you to talk to the other side and find out if the other side will actually give it to you, and then come to the judge and say, I need this sort of information. But if you don't do it in front of us, in front of the magistrate judges, you might not have an opportunity to do it in the future in front of the district judge. And so, and we're going to talk a little bit about that, but that's why it's important. And the other thing that is really important, and it's frustrating for magistrate judges, is that once we certify the case ready for trial, we don't hear about it. We don't hear about the fact that the defendant is complaining that there is discovery that was just handed to us 72 hours before trial, or maybe on the eve of trial. So, and there's no recourse to y'all for that unless you have brought it to our attention. Now, I have a practice that I ask the U.S. Attorney, you know, what's going on with discovery? Has it been complied with? Is there anything else out there that you expect to get that you haven't gotten yet? And then I don't certify the case ready for trial until I know that everybody is satisfied with the discovery production. But it's incumbent upon the defense lawyer to stand up and say, well, you know what, Judge, there is a problem. And this is what we expect to get, or we need to get, and we haven't gotten it. Because once it gets to the district judge, it's certified ready for trial, the Speedy Trial Act is running, you're not going to get a whole lot of relief. So it's important that you bring the discovery disputes to the magistrate judge.
Judge Wood, anything that you'd like to add?
Other than to just, I guess, put a point on it, as a district court judge, we justifiably rely so much on the work of the magistrate judges, particularly in criminal cases. And I know we're going to talk a little bit about whether you can supplement that and philosophies about that. But the earlier defense counsel and the prosecution gets going on the non-dispositive motions,
right,
the better shape the case becomes.
Right. Amy, anything further?
The only thing I would add is that on appeal, I see often that it seems like what is the natural course of a case is you get the case, and that's sort of in this period while you're dealing with your other cases. Your client's called you, and it's sort of, on the back burner, you're trying to do something. You can't really put your full attention to it because you're dealing with your other caseload. So during this really critical time period when the case is before the magistrate judge, you may not be preparing it as well as you would if the case were set for trial. So since you put all your effort into it when it's set for trial, the only thing I would suggest is try doing exactly that before trial. When the case is before the magistrate, try actually preparing your case, because to me that's the only way you can really know what all you need to know what to ask for. And ask for everything, whether you think that you will get it or not, whether it's traditionally given or not. Make sure you file every motion to ask for everything that potentially you could need, whether you think the law is against you or not.
Judge Braselton, once you've done a report and recommendation as to the motions that are before you, can you talk about is there any risk in the transition from you to the district court and that report and recommendation that counsel should be aware of and take note of in terms of protecting and re-advocating issues as they're coming from you?
Well, there are two great risks. So first off, of course, in the Northern District of Georgia, we do the dispositive motions as well. So we're doing all the motions to dismiss and all the motions to suppress. Generally, if it's just a standard Jackson-Deno and we don't have anything else to do, we will defer that to the district judge. But everything else we handle. And there, as I said in my opening remarks, there is a huge distinction between civil practice and criminal practice. And that is that Criminal Rule 59 first says that if you don't object to the R&R of the magistrate judge, then on appeal, even if the district judge has dealt with it by adopting it or even modifying it, you have waived any objections. So you have to file objections or they're waived. The civil realm doesn't have that provision in Federal Rule of Civil Procedure 72, so it's a more of an amorphous standard. There's not a waiver. So you have to do that. But the more critical aspect is, so you have a motion to suppress and you're in front of me and you're arguing, for example, that they needed a warrant for a tracking device. And we've litigated it, we've had hearings, and I issue an R&R against you. Now you go to the district judge and you realize that, although I take the contrary position, that you don't need a warrant right now for a tracking device. Maybe you do, maybe you don't. But the real issue in the case is the scope of the search that went on, all right? And you didn't raise it in front of me. You didn't present any evidence. You didn't argue that. Now, the 11th Circuit has said that a district judge has very wide discretion whether or not to, one, accept new facts and new arguments that were not presented to the magistrate judge. And but I would think, and I know for a fact, that about 95% of the district judges in the Northern District of Georgia will say, sorry, I referred this case to the magistrate judge, and you didn't present that argument. You didn't present those facts to the magistrate judge. You haven't shown me why there's good cause, why you didn't know this. Well, maybe the government just gave it to you. That might present good cause. But if you've just thought about the case for the first time again and you come up with a better argument, the district judges are going to say, sorry, we're not going to let you do that. You can't throw the case up against the wall in front of the magistrate judge, see if it sticks, and if it doesn't, then we're going to throw something else up there. So we're going to give you the time that you need to marshal your facts, marshal your arguments, and present them to us. But if you don't do it in front of the magistrate judge, the circuit says that that's okay if the district judge says, sorry, you can't do that now. So you have to put the best foot forward in front of us. Now, a lot of times, and if you don't do that, particularly in my district where we do the dispositive motions, it puts us in an awkward position because many times I've said, well, darn, if the defendant had just argued this, there might be something there. And it's a real quandary. Sometimes I'll ask for more briefing. Sometimes I'll ask for another evidentiary hearing. But I can't, be y'all's lawyer because that puts, sort of puts my hand on the scale, and that's not appropriate. And sometimes the problem is with the government, who hasn't argued what they're supposed to argue either. And you wouldn't want me to basically step in and help the government any more than the government wants me to step in and raise and discuss an issue that might be beneficial for you. So you have to think about it. Like Amy said, you have to treat the pretrial period in a criminal case in front of the magistrate judge, just like you would in getting ready for trial in front of the district judge. How is this going to advance my ability to get my client acquitted or put my client in a better position for a more favorable sentence? And you do that in front of the magistrate judge because you're going to be stuck in a waiver or a discretion where the district judge is not going to consider what you now want to raise.
It's a very good point. Judge Wood?
I may not fit in as well as I thought in the Northern District. If I were to come up there, I have a little bit different view of my role in that situation. And particularly when I'm looking at things for de novo review, I really do want to look at it anew. And although it is aggravating and can result in a waste of a magistrate judge's valuable time, nevertheless, I want us, while it's at the district court level, to endeavor to get it right. And if there is some issue that for whatever reason was not raised in a timely fashion vis-a-vis the magistrate judge, I still want to hear about it before we get to trial, before there is a jury verdict or a plea. And I am more lenient in entertaining later raised arguments and evidence.
Yeah. And I think experience shows I think Judge Berman is right in terms of the very strong presumption within the Northern District. But if there are issues that you stumble over and you raise in that interim between the district judge and the magistrate judge, more typically the judge is you're going to get chastised, and you might not like that. But the court is going to be concerned about protecting the defendant's rights and making sure that the process goes as it should. But really, you want to avoid that issue and avoid that circumstance by appropriately raising the issues as Judge Braselton has noted. Amy, anything to add? Okay.
I would add one more thing. Frequently what happens is the district judge will decertify the case and send it back. Now, if your client's out on bond, that's okay. But if your client is detained, it's coming back. It's going to add another 6 to 8 to 10 months sometimes to get everything resolved again before the case has been certified and certified and ready for trial. So, it's just, and a lot of people criticize the double track system that we have in the Northern District of Georgia because it's rare. There are very few districts in the country that the magistrate judges handle so much of the pretrial matters in criminal and civil cases. But we do try to get it right. I'll have district judges call me up and say, they've now raised this issue. Should I send it back to you, or what do you think about it? But they'll do that if they think that there's something there there, as opposed to, well, he's just come up with another argument which is not going to fly anyway. But it's a better practice to raise everything in front of us. Sometimes it's a better practice, instead of filing objections to the R&R and saying, well, you know, I now have this new argument, to ask the district judge to give you more time to file the objections, but move for reconsideration in front of the magistrate judge, so that we can then look at the issue, have more briefing, have an evidentiary hearing if we need it, before we then send it back up to the district judge.
Judge, in the course of your comment, you mentioned bond, and if the defendant is in custody, and the fact of how the lawyers are dealing with these procedural issues adds to the in custody time if there's not if bond hasn't been granted. Are there any appellate related issues that you would think attaches to bond decisions that the practitioner should be aware of?
Well, although there is, if we detain somebody or we release them and the government objects, the review is still deferential in at the district judge level. It's a de novo determination. They might not have to do another evidentiary hearing, might not get that opportunity. They can just review the record, because there's a little clause, I'm not sure if it's in 3142 and 3145 or it just came out of the Hurtado case, but if the district judge is going to reverse a magistrate judge and hold another hearing in a bond appeal or a detention appeal, the judge has to issue findings of fact. And district judges, at least in my district, have an average of 495 to 550 cases, and they're not really happy about sitting down and having to do findings of fact in a case. So the point is, again, this is sort of like I'm preaching to the choir here, because nobody in this room would just stand up in front of me and sit and just say, well, just give my client a reasonable bond and let's see what happens. And then in front of the district judge say, well, here's my job and parents and background and military history and all of that. But the key thing is to present your best case to the magistrate judge on the bond issue, because you might not get another opportunity in front of the district judge.
Yes. Judge, anything to add?
Just on bond, the statute is somewhat hairy, and there's a case out of the 11th Circuit, the Torres case, where if the defendant is accused of a crime, in that case Texas, he's found in South Florida, magistrate judge in South Florida makes a bond determination. The question was, which district court is going to review that? And the district court in South Florida got it right according to the 11th Circuit and said, not me. It's the district court in Texas who is to review that. Judge Barquette wrote an interesting dissent where she said, actually, a particular magistrate judge in a particular district and a particular district court judge in a particular district have I think she called it an affinity of territory, that we should allow them to work in tandem on an issue such as bond. After all, Judge Marino knows, like the magistrate judge he works with, about flight risks in Miami and bond conditions in Miami, and it doesn't make sense to split that duo up and have a Texas judge review South Florida judge. The problem was the wording of the statute, which says exactly as the majority of 11th Circuit held.
So in that circumstance, when there's a transfer into the receiving district, then the appeal or the reconsideration of the bond issue has to go to the district judge, and can't be then relitigated before the receiving magistrate judge.
And you have to watch which district judge it goes to. You got to go back to the district that has jurisdiction over the alleged crime.
Now, there are ways of dealing with that, but if you consider the basic rule is that a magistrate judge cannot review a detention or bond decision of another magistrate judge. I mean, that sort of makes perfect sense, right? I mean, we are inferior judicial officers, and so you need an Article III
Not
judge.
really.
Well, I understand that. Well, I'm just quoting Judge Joe Flatt. But in terms of what our constitutional authority is, we don't have the same authority as the district judge, and the statute is written that way. And so, but a lot of times what will happen is there is a release that might be fairly restrictive in another district, and now the defendant is removed to the Northern District of Georgia. There is some theory that reducing the restrictions on release, as opposed to changing it from release to detention or detention to release, is something that a magistrate judge in the charging district can handle. And we've also done the reverse, where somebody has been released and the conditions were not, in our opinion, severe enough. For example, in an Adam Walsh case, if you get released in the Southern District of New York, they don't tend to abide by the statute, I'm sorry, and stick the defendant on electronic monitoring. That's what the statute requires. And so, I'll stick electronic monitoring on the defendant, even though that was not part of it. But you have to think about that. And then you also have to think about, well, who is the district judge who is going to consider this release or detention issue? It frequently depends on whether or not the defendant is here on an indictment or on a complaint. If it's on a complaint, it's going to go to the duty district judge. If it's on an indictment, it's going to go to the district judge who is assigned the case for trial.
Amy, any comments on that?
No, nothing.
You don't deal with bond issues.
I do. I mean, I have bond issues on appeal, and I've had several of my defendants ask for, and I've come close to getting them bond by the time. However, if the district court judge hasn't granted bond, it's unlikely they're going to get it on appeal, but it's a motion that can be filed.
Moving from the various issues that you would commonly see at the magistrate judge level, I want to talk a little bit about trial-related issues, and obviously the transition from the magistrate judge to the district judge. So, Judge Wood, let's talk about issues that you commonly see that practitioners might benefit from thinking about as they go through and transition ultimately to the appellate process. Jury selection, even.
Let me start just overarching bit of advice that I got when I was a practicing attorney that was some of the best advice I ever got appeal-wise. It's also some of the least sexy advice I ever got, to all but maybe Amy. And that is, you need to, from the inception of your case, think about the appeal. We like to think we won't be on the appellate side when we first get our case, but when you get your trial notebook, either electronically or physically, include a tab in it for appellate issues. And that way, from the beginning, you start thinking along those lines, along making a record lines. In that notebook, along the way, include things like what the various standards of review are going to be for hot button issues that you think you'll encounter as you go forward. include things like whether proffers are going to be necessary for certain issues that you have witnesses ready to make that proffer, be ready to straighten your spine and demand the opportunity to make a proffer. Think about and put in that appellate tab evidentiary issues that you feel like you're going to encounter and might possibly lose. Have on the tip of your tongue the exact rule of federal evidence that governs that, and arguments and case law that might help you with that. Along the way, during pretrial motions, during the trial, and beyond, refer to that tab and add to it every single thing that happens. The questions that you propose that you would like to have asked or asked yourself on voir dire that were denied, make a record of why you wanted to know that from those jurors. Make it clear on the record that you were denied that opportunity. Batson is, as you know from reading the case, fertile ground for appeal and a fertile ground for some successful, pretty breathtaking appeals. In particular, you'll want to have in mind the familiar three-step procedure. I'm surprised at myself and at others that sometimes can stumble on that. We all know what it is, and yet sometimes people still have trouble with it. The point I want to emphasize is that 2 of those 3 Batson steps involve, unlike the other things we've been talking about this morning, which are all on the paper and clear who said what, Batson at the initial prima facie step, and then at the later view to determine whether the strike was pretext for purposeful discrimination, both those inquiries can involve things that are seen and heard in the courtroom, but are not necessarily verbal words that the court reporter will get down and be something that Judge Choflat and the others can read. It involves, by its very nature, things like scowling, things like long pauses, things like shuffling the feet, things like people sleeping, things like the judge standing up and trying to walk out while he's asking you anything else. All those things will not show up in the record unless you make them show up. And of course, the goal is to do it in a way where you don't appear obnoxious or like a jerk and somehow rile the tempers of people that are going to be deciding other things on your behalf. It's a hard line to walk in front of some judges, but a really crucial line to walk. Of course, in the prima facie case, one of the most important things is to look at the numbers. Person had 7 strikes. He used every single one to strike the African Americans on the panel. Don't accept what the judge says necessarily or your opponents say necessarily about what transpired during jury selection. Very quick case in point, had a Batson challenge in Augusta, Georgia years ago, and the challenger made just that argument. It was a civil case. He said they had 3 strikes. They used every single one to strike African Americans and only struck African Americans. The opposing side, the proponent of the strike, didn't say anything factual about that, but just started into explaining the neutral reasons. Well, the fact is, one of the strikes was not an African American. One of the strikes was somebody that I've known since I was 16 years old and went to law school with. He had blonde hair and blue eyes, and for some reason in the heat of the moment, people just didn't, even the person that was trying to strike him said, well, I struck him because he's a lawyer. I thought he'd take over the jury room, instead of pointing out he's a Caucasian person. And the other side didn't even notice it anyway. We ended up calling this gentleman to sidebar and asking, can you just say on the record, what race do you consider yourself? He looked at me like I was the biggest idiot in the world. And actually he didn't. Actually, he said, Caucasian? So that's an extreme and dramatic example. The more common than you might think, is for one actor in that Batson play to say, I struck juror 7 because she wouldn't look me in the eyes. She had her eyes closed. And maybe that's not the case. But if you don't speak up about it and say, I didn't observe that, that will be the case that the 11th Circuit looks at. So it's very important that you make a verbal record about how you see what's happening there, or else it's lost, and only your opponent spoke about any of that. This is more difficult, but the same for the judge. When, as we know in the third step of the Batson challenge, they look at the totality of the circumstances, and a very important one is demeanor and a credibility determination. Those two are things, if you're on the losing side, you need to try to get on the record any evidence you have that goes contrary to that. We've seen some sort of explosive cases in Georgia in the last 18 months with regard to capital murder cases and those coming back because of Batson notes. Always remember what you're writing down in your notes, and always remember that your opponent is writing things down in the notes. The Chapman case that reached the Supreme Court out of Georgia did so because the appellate attorneys made a strong open records request for those notes, and it was a gold mine. You can make a record at the trial level about what records exist for perhaps later usage. I'll stop.
Very good point. Again, the adage being that if it's not in the record for appellate purposes, it didn't happen. And so you're always wanting to be mindful to protect that record. Amy?
Well, I was just going to say that I was hoping that Judge Wood was going to say, rather than keeping an appellate tab in your notebook, you actually keep an appellate lawyer with you. Because appellate lawyers can help you to preserve your record. Because, I mean, really, appellate lawyers look at things differently. I was a trial lawyer for 8 years, 2 weeks. Rick wished I had been a trial lawyer for 2 weeks, but instead I was a trial lawyer for 8 years, 9 years. And it's just a totally different mindset. You're getting ready for trial. You've got all the evidence. You've got to defend your client based on what you're watching, what's going on. You're not thinking appellate. I mean, how can you be? It's just a different thing going on, and you're also not sitting around reading all the cases in the universe on it. Appellate lawyers, that's all we do. We read all the cases. I keep up with all the 11th Circuit law. That's what appellate lawyers do. They're looking out at the broad picture of what's going on. They know usually, not always, but hopefully, what's going on in the Supreme Court, what the hot issues are to help you with that, because you just can't do everything. And they're just different skill sets. So if you have a big case where you can afford an appellate lawyer there, and I would also think, I've seen CJA cases where there have been more than one lawyer involved in the trial. If it's a really big trial, even if it's a CJA case, to go ask, can I get a CJA appellate lawyer attached to it for as early before the trial as you can and during trial. It's very helpful for preservation of issues on appeal, and that's an advertisement. Not just for me.
Well, I'd just like to add one thing, that what I find that lawyers don't do enough of is an offer of proof. They take the ruling of the judge and they say, that's I object and that's fine. But you need to stand your ground if you lose on the objection, you need to perfect the record and say, Judge, I would like to make an offer of proof, and I'd like to do it now. And the judge is going to say, well, no, we'll do it at the next break, and then you forget about it and it's done. But you need to make sure that you make that offer of proof. Not a lot of times, but frequently you will, run into a judge. I think not so much in the federal system, but in the state system, where the judge is going to push back and not let you do that, and you need to file something at the latest the next morning. This is what I wanted to say. This is what I was prevented from saying, and this is what my offer is. It's a little more difficult now because almost all proceedings are recorded, but it used to be in the state courts in Georgia. The court reporter, you would look, and her hands or her steno mask would come down when you were fighting with the judge. Pretty much everything is recorded now, but it's you have to do that. You have to make sure that you're not being stonewalled and that you can make the record.
Along with the nonverbal cues that we've been talking about, be aware of the whole courtroom space, and if there's rule of sequestration problems that occur, if there are witnesses that occasionally slip in, sometimes in good faith, but nevertheless mistakenly. We've had a string of cases out of Florida where the defense attorney herself was not in the room for about 30 seconds before the trial began, and there was a little bit of questioning while she was still trying to get through the security gates, and that generated a 101-page opinion from the 11th Circuit about the effects of that. But be situationally aware of the room and what's going on, and get all of those nonverbal things on the record. Sleeping jurors, whether we've got a nodder in the back that's signaling to the witness what to say yes to and so forth, none of that appears on the record unless you make it.
Right. Good points. Judge, have you seen any areas, talking about supervised release, any kind of appellate concerns that you've seen in that area?
Yeah, the supervised release, that's sort of the stepchild of sentencing. As trial lawyers, we come to the sentencing show to hear how many months. I mean, that's what you're there for, you and your client. And once that's announced and the judge sort of drones on with that familiar supervised release findings and so forth, the defendant himself and defense attorneys, the prosecution, tunes out a little bit and is starting to think about how many years that is and where it's going to happen, and am I going to have to report immediately? And they can sort of shut down and go to sleep a little bit on that 5 minutes of talk about supervised release. Well, for whatever reason, the appellate courts are not asleep on that lately, and there's been a lot of case law, for whatever reason, emanating out of the 7th Circuit primarily. But the appellate courts are looking hard at supervised release conditions that some judges are mechanically or robotically just adding. The law is shaping up that you shouldn't just mechanically impose special conditions. Some of the ones that are particularly under target are some of the sex offense conditions about treatment, about restriction of material that you can watch or view, watching adult pornography, also location monitoring, ordering treatment, ordering drug tests, a whole host of what used to be just slap it on the appellate courts are requiring an individualized, particular assessment of whether those conditions are in fact in order. And in order to do that, the district court should balance, on the one hand, the liberty deprivations that those conditions entail against the statutory and policy purposes of sentencing. And in order to have a sentence that I think goes the distance, district court judges are learning to make that individualized assessment. If it doesn't happen in your case, you should object to that. What's interesting is, like I said, most people don't object to it, particularly if your guideline range was 97 to 121 months and the judge sentenced you to 12 months and a day. You feel a little sheepish saying, you know, do I really need to do drug testing? It looks like that's going toward plain error review. Even without an objection, certain of those conditions, the Supreme Court weighed in a case out of North Carolina, the state system, that the Supreme Court said there's First Amendment problems with just routinely requiring people not to view certain things. All that is to say that supervised release conditions are sort of having their moment in the sun lately.
Amy, anything? Yeah? Okay. And one of the areas that probably most practitioners do focus on and think about for appellate purposes is in the area of jury charges. Because at the jury charge stage, whenever the court schedules that in the course of the trial, you really are thinking about appellate issues. Obviously, you want whatever charges you're asking and advocating for, but you're thinking at that stage probably much more intentionally about the consequences of the court's ruling, because you're getting ready now to tee up the legal issues that you anticipate being available to you for appeal if you don't get the ruling that you're looking for. Any advice or any suggestions along those lines, Jack?
With regard to jury charges, just in shorthand, research as thoroughly as you can to find the ones that are helpful to you. Submit them in a timely basis. If they're denied, make a particularized objection as to why. There's a three-step process that the appellate courts use in reviewing a district court's failure to give a charge. The first two are usually pretty clear. The last one, what hangs up a lot of people. Of course, the requested instruction has to be substantially correct statement of the law. Second, it has to not be covered by the charge that's already included. And the point that hangs people up, including this week in a case called Fosha, is the issue has to be dealt with at some point so that it's important enough that failure to give the requested language or the requested charge impairs the defendant's ability to present an effective defense. So for example, I think on Wednesday, the 11th Circuit rendered a decision in a dealing in firearms case. And the defense attorney wanted to add to the pattern charge that it's okay to have as a hobby buying and selling guns. As we know, the pattern charges aren't the be-all and end-all. They're a good guide, but they're not completely a safe harbor. The pattern charge in the 11th Circuit tracks some of the statutory exceptions in that statute, but not all of them. And one of them it doesn't track is hobby. It turns out that is a correct statement of the law, that a hobby is an exception. The lawyer very diligently requested that exception, and the trial judge denied it, and the 11th Circuit said that's fine, because the lawyer was tripped up on the final requirement, and that is the evidence just didn't bear out that this was a hobby. It was buying and selling guns for profit every day. So not only do you need to have the right law and submit it, but you have to shape your case to where it matters, and then explain why it matters while you're still at the district court level. I'll add just a few quick things about jury charges. Don't forget that I guess most district court judges read the charge after you've had the conference, after you have heard of the objections. Don't forget to follow along as they read. There are mistakes that are made in the oral presentation of that charge. It's a good mistake to catch if you have one. Most district court judges allow a written copy of the charge to go out with the jurors, which I think is really should be imperative. Sometimes the charge is 65, 70 pages long. There is no way that even a lawyer in the jury is going to catch all of that at one reading. Ask the trial judge to give each juror their own set of charges and proposed verdict form. I know from having interviewed jurors, sometimes that can be an issue back there in the jury room with who holds those and who controls them, if the judge is jealous and passing out copies. So it is important to get all those copies out. Last thing I will say with regard to jury charges is most judges do allow you to know, to use and put up on the screen written snippets from the charge itself. I've found in interviewing jurors post-judgment that makes a big difference when you utilize those. Not direct quote from jurors is, that lawyer really knew the law. You know, he knew what you were going to say even before you said it. And they don't know that you got a copy of it, but it does lend credibility to you when it looks like you're prescient.
Yeah. Amy?
I think that's such a good point that you made about jury charges, that I see so many cases where everybody's thinking, well, these are the pattern instructions, these are good, they look okay to me. And as a defense attorney, it's really, really helpful if you go through all the law in the circuit that's binding precedent, that's favorable for your client on every single issue that's going to arise in your case, and then try to fashion a jury charge on that that's going to help, because jury won't know about these helpful things unless they're charged it. And the pattern instructions are sort of the bare bones, the very basic about what they need to know in order to convict. It doesn't have anything to do with what they need to know in order to acquit, and which is part and parcel of, a lot of times I hear people say, well, I didn't ask for that because I didn't think the judge was going to give it. Or, judge never gives that. Or, I don't think the judge would want to give it or hear from me. That's not a reason not to ask for a jury charge. You want every favorable jury charge to be in there, because the jurors, that's their lifeline. That's what they're operating under. And number two, you don't ever assume. I had a lawyer not that long ago tell me a fact about a case of his, and I had thought his client was just really a terrible case against him, and terrible facts, and he brought up a fact that I didn't know, and it changed my entire opinion of the defendant and all the facts. And I said, well, the judge wouldn't let you get that evidence in? And he goes, well, I didn't ask, he wasn't going to let it in. Well, okay, how do you know he wasn't going to let it in? He didn't ask. I was like, ask. I mean, even if you don't think the judge is going to let you get in really good evidence, even if you don't think the judge is going to let you have a jury charge, even if you think the law is against you, because you've seen the law changing, ask. Because if it's really good for your client, it could actually help you. And my third thing, which I shouldn't veer off on things, but yesterday our soon-to-be Judge Mike Brown was making the point about talking about his client and putting in information about his client that ended up probably being the reason he was acquitted. Think about your case in those terms, too. I mean, it's true of all the things that are going to help your client, all the evidence, all the facts, all the jury charges, anything that's going to help them, ask the judge and try to get it before the jury. Because I read these, and it's not in the record on appeal.
Now, I'd like to say two things. First of all, judges tend to be conservative beings, and they don't like to stray away from, for example, the pattern jury instructions, because they feel, there's a fairly decent chance if I give the pattern, the circuit is going to affirm that. So, and I do a lot of 2255, so I see where there was, claimed error, the judge didn't give this instruction, and what the lawyer did is just submit an instruction which is just the language of a case, the holding in the case. For example, that hobby is an exception to dealing in firearms. You have to formulate the jury charge that you want the judge to give. It's in a holding. Judge Murphy used to always tell me that the holding in a case is not a jury charge. You have to formulate it into the charge that you want the district judge to give. And Judge Wood had spoken about what your issues on appeal are. A lot of times lawyers don't look to see what the jury charges are going to be in a case until after the evidence and the judge says, all right, we're going to have a charge conference, tomorrow morning at 8:30, show up. And now you realize that, you've submitted your charges because, well, this is a fraud case and, this is it. You really have to work on your jury charges as you're preparing your defense and make sure that whatever jury charge you need to hang your hat on, you have the evidentiary support and the proper language to try to convince the district judge to stray from the pattern charge and to give that charge, and to make sure, again, if the district judge doesn't let you put in evidence about hobby, that you have proffered the evidence about hobby or whatever the issue is. So the jury charges have to be thought of, very early on in the case.
That's a very good point. I recall that when I started out practicing at the U.S. Attorney's office here in Atlanta, what I was taught and really came to really appreciate was the practice of, once you get your case facts and you start to understand what your case is, go to the jury charges to figure out what all the elements are and how they're going to be factually borne out by what you've got. And you can structure your case, you can organize your case around the notion that at the end of the process, I'm going to have to establish these particular elements. And the other part of that would also entail looking at all of the annotations, or at least the relevant annotations having to do with the case that you anticipate bringing. And those were just always invaluable, that you were so well informed as to how you needed to either structure the evidence or things that you needed to make sure that you had appropriately in the record, but you wouldn't know it if you only looked at it at the end of the process. And so I always found that to be good advice, and sort of adhered to it fairly religiously at this stage. It's always served me well, and I would offer that. Amy, you cornered us this morning because you wanted to talk about an issue that was near and dear to you, and I want to give you full opportunity to talk about it, because it's an issue that I've had questions and concerns about myself, and that is when the U.S. Attorney requires that a defendant, in order to enter into a plea agreement, must, in advance of any kind of appellate issues coming to the fore and even being aware of them, they're requiring that you waive any issues. And it would seem to me that there are a number of potential concerns that comes out of that entire area of the law. And I know that you've given a lot of thought to that.
I
Care to share?
have given a lot of thought to waivers of appeal because when I was in the U.S. Attorney's Office, working under Joe Whiley, we drafted and instituted the waiver of appeal policy, which was one of the first maybe in Georgia, and I think they came in the other districts after that. And now I'm in private practice and I get to look at what these things look like. So waiver of appeals are really an important thing that can really help a defendant. You just have to make sure when you enter into a plea that your waiver of appeal actually helps the defendant. One thing that's important to understand about waivers of appeal is you can put exceptions in them. And if you do have legal issues, we early on even had, it was maybe so informal, not everybody knew about it, but everybody in the office knew about it. Maybe the bar didn't. And I think maybe in the office they probably still do this, is if there's a significant legal issue that you're hung up on, accept that from the appeal waiver. Just about all appeal waivers, I think everyone I've seen in Georgia at least, has an exception for if the judge departs from the guideline, varies from the guideline, if there's an illegal sentence, or if the government appeals. Those are in all of them. But, you can make your waiver of appeal look different by putting in an issue that's a difficult issue, in addition to entering, a conditional plea that you opt out on waiving a suppression issue or something, but also just a guideline issue you can put in there. I think one thing that you were asking me was, what are you waiving when you enter into a waiver of appeal? There are different waivers of appeal in different districts. The Northern District of Georgia, you waive your right to appeal your conviction and sentence. Southern District, it's you waive your right to appeal your sentence. Only. I don't actually think they're much different. We discussed that. Waiver of your right to appeal your conviction happens by entering a guilty plea. You've waived your right to appeal all non-jurisdictional claims. A jurisdictional claim can't be waived anyway. So the 11th Circuit has been clear that a jurisdictional claim can be raised by the court at any time. It's unwaivable. So I haven't been able to figure out. Since I left the office, they added the language, waive your right to appeal your conviction. I just don't think that's any different than I plead guilty. They also have language in there about collateral attack. You waive your right to collaterally attack. Keep in mind, whenever you enter into a waiver of appeal, you don't waive your right to appeal all collateral attacks, even if that's in there. You don't waive your right to appeal an ineffective assistance of counsel claim. You were going to ask me, and I'm usurping you're asking me, but the Williams case made it really clear that made it pretty clear. It's clear to me that you can't waive your right to appeal an ineffective assistance of counsel claim if that's truly what it is, ineffective assistance in entering into the plea, like you weren't guilty of it or something. He had you agree to some amount of drugs where that wasn't in the PSR and it's not in the case. I mean, there are things that you just can't waive. Ineffective assistance of counsel also sometimes you try to raise that on appeal. It's really just an attack on the sentence. That is waived. So that's why when you see the cases that say you can waive your right to raise an ineffective assistance of counsel claim, that's what they're talking about. If it's really just, I don't like what the judge did, my counsel was ineffective in not arguing it better, and the judge did it wrong. No, you've waived that. It's just really an attack on the sentence.
Yeah. Judge Wood, any?
I'll say this. I take 100 or so guilty pleas a year, and I'm looking at the defendant the whole time. They take approximately 30 minutes each time. When I come to the part where it's waiver of appeal, there is a look on most defendants' face that changes at that point, because there's something about that. I've already covered all the rights that you waive by pleading guilty, and every time I do it, I think, are they really going to go forward with this? Because as I go on and on about all the rights that you're waiving, you think, are they really going to do all this? And They do, 99% of the time. But when I get to the appeal waiver part, there is a change, and it's at that moment that they seem to be contemplating it the most, and for good cause, because I do think an appeal waiver is a mighty, mighty thing, a big right to give up. I have some question about whether it is okay for a district court judge to allow the prosecutor only to cover that in the Rule 11 colloquy. There's sort of a side comment, an 11th Circuit case out of Alabama that seems to indicate it needs to come out of the district court's mouth himself. The Southern District has morphed a little bit into what the standard plea waiver is. It now is conviction and sentence on any ground other than the same 3 exceptions that are employed in the Northern District. The collateral attack waiver, the standard one, spells out that you're not waiving a claim of ineffective assistance of counsel, but otherwise everything else. I routinely accept any exceptions on top of those 3. If they want to carve out a suppression issue or carve out whether I'm in fact an armed career criminal and fight that another day, I think that's advisable.